Hey guys, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. The judge has issued a ruling in the Justin Baldoni versus Blake Lively case, so we're going to take a look at what he had to say. This is a ruling on Blake Lively's motion to compel. She's been seeking certain financial information from the Wayfarer parties. For Abel, Nathan, Baldoni, Heath, and Sarowitz, they call for documents sufficient to show your net worth, including financial statements, assets, liabilities, and tax returns, and all documents concerning your liquidation of assets in 2024 or 2025 for any reason related to the film or the actions, including but not limited to the sale of shares in any publicly traded company. For TAG, Wayfarer, and It Ends With Us, they call for your tax returns, financial statements, and year-end balance statements for the period June 1st, 2020 through the present, and all documents sufficient to show your gross income, net income, and expenditures. Federal Rules of Civil Procedure 26b1 provides that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense. Relevancy under Rule 26 is to be construed broadly to encompass any matter that bears on, or that reasonably could lead to other matters that could bear on, any issue that is or may be in the case. The Wayfarer parties are seeking substantial economic damages in this case from Lively's alleged tortious conduct. He's quoting the complaint here saying the Lively parties have cost the Wayfarer parties their file, their reputation, their future prospects, even their talent agency. Also alleging that as a result of the tortious conduct of the Lively parties, the Wayfarer parties have suffered loss of income and interference with future income and sustained harm, including to their business and profession. They made a prayer for relief seeking a money judgment representing compensatory damages, including consequential damages, lost wages, earnings, and all other sums of money, together with interest on those amounts, and an amount to be proven at trial, but in no event less than $400 million. Documents sufficient to show the net worth of each of the Wayfarer parties, including financial statements, assets, and liabilities, and for the corporate entities, financial statements, year-end balance statements, and documents sufficient to show gross income, net income, and expenditures are relevant and should be produced. However, Lively has not shown an entitlement to the tax returns of the Wayfarer parties, due to the private nature of the sensitive information contained therein, and in part from the public interest in encouraging the filing by taxpayers of complete and accurate returns. Courts have long been reluctant to order discovery of tax returns. A party seeking to compel production of tax returns in civil cases must meet a two-part showing that 1. The returns must be relevant to the subject matter of the action, and 2. A compelling need must exist because the information is not readily obtainable from a less intrusive source. Although the returns are relevant to the subject matter of the action, Lively has not shown that the information she seeks will not be contained within the other documents she has requested and that the court has ordered be produced. Lively has also not shown that documents concerning the liquidation of assets by Abel, Nathan, Baldoni, Heath, and Sarowitz are relevant to the claim for damages. Lively's motion to compel is accordingly granted in part and denied in part. So here he's saying they have to produce the documents responsive to the request for production, except for tax returns, by no later than May 28th. The request for tax returns and the motion to compel documents responsive to RFP 47 to Abel and Nathan and RFP 59 to Baldoni, Heath, and Sarowitz is denied without prejudice. The court awards costs to neither side. So in other words, the judge granted the motion to compel documents that Wayfarer has already said they're going to produce. Even in the letter we read this morning, they had said, yeah, we said we are working on it. So, all right, that's all I got for now, guys. Thanks for watching. I'll see you all soon.